All right. Hello, everyone. Welcome to KDC's Boost Camp. We're already on session 6. So we are starting a few minutes late, so I'll just do a few quick reminders. Thank you to the Cooperative Development Foundation, who is sponsoring $15 meal vouchers for this program. So if you'd like a meal voucher and haven't already heard from me, you can reach out to me at hannah@kdc.coop. If you were at the last session and haven't received your meal voucher yet, I am just running a little bit behind, so you should be receiving those at the end of this week. With that, jumping right in. Tonight for session 6, we have Will Pillsbury for our speaker for, oh wait, I forgot to ask our legal Q&A. Just for a quick introduction, Will Pillsbury is a member of the Pennsylvania and New Jersey Bar and has been KDC's go-to legal consultant for as long as I've been on the team. I know folks have submitted or have a lot of questions, and we're only together for an hour. So with that, I will pass it along to our speaker. Thank you so much for being here.
Good evening, everyone. I hope everybody's doing well. Just, I guess what I was hoping for is some back and forth, but I did get some questions. So I think it's probably a good idea to just start, and then hopefully that sparks some discussion. The first question I received was about membership agreement, what needs to be included. So I think the key thing to realize membership agreements, there's really 3 things they're supposed to do, which is explain the rights you have as a member of the cooperative, explain what the responsibilities you have as a member of the cooperative, and then explain what the cooperative, the responsibilities members have, explain what the obligations the cooperative has to the members. And so that sort of broad picture. Within that, rights are pretty clear. You want to make clear what's in the bylaws. I always recommend either including a copy of the bylaws or making it clear how people can get a copy, because that'll provide more detail. But you want to sort of talk about, your rights, 1 vote or however many votes. If you have a right to certain financial incentives or financial status, you want to make that clear, the patronage rebates, the dividends. That should be laid out. It doesn't have to be laid out in as much detail as the bylaws, but a brief outline, and then sort of talk about what committees or board of directors, that kind of thing. You want to make sure people have a thumbnail idea of what their rights are. And then the responsibilities is important as well. And that goes to sort of the obligation, the responsibilities, sort of what they have to do as a member. Often it talks about the mission of the cooperative and what they have to do. As part of it, you also should clarify what it means to be a member, what are the member categories. And then clarify adhering to the policies and procedures and all of that, support the capitalization and what that means, the financial obligations. Then the last thing is the obligations the cooperative has to the members. That's the sort of, sometimes I think it's sort of forgotten in there, but you want to make sure that there's a clarification of how notice will be provided, where they can find the bylaws or other documents. Nowadays, most things are on websites, so you want to make sure the website is known, and sort of the nature of how business would be conducted. And then, again, the financial contributions and any kind of payment, and including what happens if there's a loss, which I'm going to talk about later. Last key thing is it has to be signed. It can be an electronic signature, but it needs to have a signature page. I know that seems kind of silly, but it should be in there. And as part of that signature page, you want to make clear, I recommend having the clarification if there is a way to, if you have some kind of membership contribution, and it can be above or beyond, or number of, if there's stock values or things like that, it should be put in there about what the contribution is. So it's in the initial writing, so that there is clarification as to all of that. Does anybody have any questions about membership agreements and sort of the big picture? I should clarify, these are like good practices. I am recognizing it's a contract and you have an obligation to make the terms of the contract clear. Okay, I guess not. Then I will follow up with the last question on my list, but sort of ties into this, is about managing when losses occur. So the real question is less about sort of that aspect and the legal considerations. So obviously any entity has a risk of loss. Cooperatives are not known for often having a lot of success, especially early on. So loss can be an issue. I think there's two types of concept of loss here, but the big legal consideration is you want to make sure it's clear in the bylaws and again in the membership agreement what it means for, let's say, if there needs to be a call of additional capitalization to cover that loss. How do those processes work? How do people get notified? And what's the way for a member who no longer wants to be part of it to divest their membership, and sort of what the expectations are if that occurs? If you don't have clarification and you don't really have it clear as to what the process is, there is exposure at that point. That's where legal issues can come up, because then people could start arguing about that the board of directors especially is acting outside of the scope of the bylaws and therefore is potentially personal liability as well as corporate liability, and people can then seek whatever, if they contributed, they could try to seek their contributions back. And you could have those type of challenges. So it's important to have it really clear, the entire process, and to be open about it. I know it's hard. I was part of a co-op. I was on the board of a co-op that failed, and I was part of the board that was at the end. And those are tough meetings to have. There was losses, and there was a lot of conversation about that. But I and the other members of the board felt it was important to have a lot of meetings explaining where we were financially, what the process was. In that case, we were doing a dissolution and sort of going through the process of how it would work, getting the support of the membership, as much as one can get the support of the membership, but making sure they were informed and where they had the rights to vote, that they were included in that. It was a lengthy process. It was an important process. We had some assets. So it was a discussion of what happens when those assets were sold. And then the hardest conversation, of course, is often that sort of categorization of what happens when you do receive some money. And in our case, we sold a building, and a recognition that a vast majority, I think all of it, was primarily used for debt services, and the members got very little just because of the nature of where we were at the loss. But that was, we had made clear within the bylaws of that structure of, sort of who gets it first. And that played a big role. Hey, somebody have a hand raised? Nope. So,
Actually,
then,
Will, there is a hand up now.
okay,
Jason's got one.
Jason.
Thanks, Will. And appreciate you being here. So a follow-up came to me as you were speaking about that, which is to say I've read a lot of co-op bylaws, and many of them I think are not really squared away on these type issues. And so I'm curious to hear your thoughts. Certainly the best way to deal with that situation is to identify before there's an issue. We're not as squared away on X as we should be, and let's try to revise bylaws and tighten it up. Can you distill any best practices as far as how to navigate a situation when you have a situation that, like, you find yourself in the middle of a situation that the bylaws do not speak clearly about?
Sure. I mean, some of that will be there'll be a lot of this is where education or sort of discussion, open discussion. In our case, I want to be clear, our bylaws were good about some of these elements and not others. The hardest part was explaining the idea of secured creditors versus unsecured creditors, and how a secured creditor always takes priority. That's a very deep legal concept, but is a very much ingrained one. So in our case, this was a food co-op. Obviously the mortgage holder gets their, that's coming off the top, but that you have to explain that. And other people who had liens on the property would jump everybody else, because that's the nature of how liens work. And there was some of that kind of discussion. When the category came down to the members, there was a clarification that member payment only occurred at the very end after all of the other groups were reimbursed. That was helpful to have in there, but it wasn't clarification as to who gets what loan provider, and who, that order was done through a legal process. And what we did is had open discussions, discussed the legal issues, made sure we had votes where it was appropriate, and sometimes just said, this isn't something we can vote on, this is just the law. And, I would say the key thing that I felt was the most important part was to sit up there and let people yell at us a little bit, because at a certain point, that's some of your job as a board, and letting that frustration out was important, and to make sure there were minutes of it all, so that if anybody had come back and said you didn't notify or all of that, that we could show that we did. It was unpleasant. I mean, it was lengthy hours, multiple times, but I think what the main lesson I got out of it, and often what I would say is, there's times where lawyers will tell you that shouldn't be in an email and you don't want to write that down. And there's times where we'll tell you that it should be written down. And this is one of those ones where I think it's a real benefit to write it down. So, there's a forthrightness that's beneficial in a situation like that. And then if you do see something where you think there's a hole in the bylaws, then I think amending them is an important part. And there's you definitively should have a process on how to do that. Related to this, I think the question of liability came up. What type of insurance should new co-ops carry? And what type of liabilities do the board of director and members have? How to insure against? This is a difficult question because there's a lot of subcategories with insurance. Obviously, if you have property insurance, you want property insurance, and property here can be sort of broadly defined. If you're a renter or if you are renting space, you'd want some of the type of insurance, the rental insurance, and there'll probably be requirements as part of that. I think this is more focused on the sort of board of directors insurance. And then there's also a volunteer insurance you want to talk about. So board of directors have D&O, that's called directors and officer insurance. That is an important insurance to have. Board members I would not serve on a board that didn't have some level of D&O insurance, because if the board is found to act in a certain way, the board members can have individual liability. The D&O would provide that. D&O insurance is sort of a weird one. It covers, most D&O insurance covers, if I remember correctly, they do a side A, a side B, and a side C, which I always found sort of funny because it implies there's three sides of a paper. But it covers the entity itself. It covers the individual, covering the company's losses. So side A is covering the directors or the officers. That's the sort of individual insurance. In most structures, side A would have its own limits of liability and normally doesn't have any deductible, because the recognition is that that's normally not sort of there. Side B is the stuff covering the company's losses. So if the company is being sued in some kind of like a shareholder or a member dispute, and then side C is covering the entity itself, and that's sort of in a third party-ish thing. It's the difference between side B and side C is complicated, and I don't think we're going to want to go deep into this. The key things what the D&O covers is breach of fiduciary duty. Obviously, board of directors and the company itself has a fiduciary duty to its members, its shareholders. If you act not in the best interest as that's defined, that's where the coverage comes in. And the important part of insurance is even a frivolous suit can occur, or even one you think is frivolous, and they can be very expensive. Legal costs, people like me do charge a lot. And, in a long litigation, that can be devastating to most people. And so that's why the D&O insurance is good, is important. It often covers negligence. It often covers mismanagement. It can cover some intentional acts, but not all intentional acts. The cost is going to vary dramatically, but it's really important to have that. You also, if you have other type of volunteer types of insurance that you're going to want, I'm going to pull up, I can't see any good ones on here, but nonprofit protection. So there's some for nonprofits and there's other ones, but they have different names. The ones I've heard of is volunteer liability coverage. It's sometimes within your greater employment, which is your E&O. So, you have these different ones. There's a lot of acronyms in the insurance business. what I would say is with insurance is if you have a broker who you're working with, if you tell them sort of what your business is, they can really help with that. If that's not something that's available to you for your size, what you sort of have to ask are where you have your vulnerability, where you have your exposures. If you've got property and people coming on your property, well, then you probably need property and you need CGL, which is commercial general liability. That's your classic third party slip and fall type insurance. You got a board, which you will have, that's your D&O. If you have volunteers or staff, that's your E&O. If there's a lot of money and you've got some concern over it's like cash business and you have some concern over fraud type of stuff, you can have a type of fraud insurance, even what's more or less a bond less than an insurance. And so there's a lot of elements here. I did insurance coverage years ago. It gets it goes very fast into sort of super weedy. So I don't know if people really want to go that far down the path. But the big ones I would say is you need your D&O, you need your CGL, and those are sort of the ones that you sort of think of most prominently. And then you kind of need it's EPLI is the employment one. So I hope that makes sense without going into mind-numbing insurance discussions, which I guess we could do, but I don't think anybody wants to do that.
So D&O, and you said it was CPLI. Is that what you said?
EPLI is
EPLI, the employee, yeah.
So yeah, I mean, that's employment practices is what the actual language. So that covers businesses by your claims by your workers that their legal rights or employees are not been violated. So if you have employees, you kind of need it. Your CGL is what happens when other people sue you. So that's commercial general liability. Those are if you look, you could sort of see that those are sort of the big categories. And again, the EPLI covers employee sort of suits. CGL would cover the third party suits from outside the company, and D&O covers sort of that other element to it. If there's sometimes you can get what's called intentional acts. That's a trickier one. That is if you see that more in cases of like high cash businesses or things where you have a real concern. Banks might have something, where embezzlement, fraud, that type of stuff. I would hope most cooperatives aren't really worrying about that, but it does exist. And it can matter because some of those type of intentional acts would not be covered by your average insurance policy. It would cover the D&O element of it, but and nowadays, I guess the big one to pay attention to, which is covered in the sort of discussion we have, is sadly there's a lot of financial stuff that happens now. A lot of us have the credit card issues. I'm sure most of us here have gotten that notice that our credit card was used by somebody in another state. That sort of thing for most banks, sort of it's covered as part of just the credit card. But if you are doing something through a lot of transactions through the PayPal or those type of elements, which is a little less bank, or if you're doing a lot of wire transfers, you want to be cautious because sometimes those are not covered by insurance policies.
Does that include, is that just regular business practice or like the transactions of your business, or would that include all of the work of your business, like membership, accepting membership shares?
I'm not sure I'm following. You mean like so it's more about like if a fraud occurs, so financial protection is what I'm sort of referring to. I think the classic one you see out there now is if you're doing wire transfer, somebody clones an email address. They send, so let's say if you had, let's say you're doing your member distributions and a member wrote in and said or not a member, but somebody who looks like a member by using a cloned email address. A cloned email address is, like my email is W Pillsbury. If you make it WPI capital I LSBURY, it looks to most people like my email address, but it's not. That can trick you. And then they say, hey, send it. I just changed my bank account. Please send it to this one instead. And then that money often moves very quickly between places and ends up out of the country. In extreme cases, there's commercial crime and cyber liability insurance. And if you're dealing with enough risk with that, that's where you can go with that cyber liability. It was a growing policy over the last few years. I don't know if what the sort of size businesses we're normally dealing with, if it really is cost effective, because those type of things are often fairly expensive premium wise, and there's deductibles and all of that. What you'd probably be more likely to do is have it covered more in an umbrella type structure. So does everybody know what umbrellas sort of do? Yeah, they're the drop down. They kind of cover everything and drop down to fill the gaps, but they don't normally cover as specifically, and they're always secondary to the primary policies. So that's a fun insurance discussion. Next up is producer co-op, transitioning responsibilities from members to co-op for liability for products, quality assurance for products. I'm not 100% sure I understand what this question is. I'm just reading it as the note I got. So if somebody is on who asked it, if you could clarify what you're looking to find out, otherwise I'll just guess.
Ron.
Oh, that was wrong.
Made the question, so you can just send him the answer if you want.
Okay. No.
Yeah. Yeah. I mean, you could take your best guess if you want. I'm also not sure that he was asking necessarily on behalf of anyone that's currently on the call right
Okay.
now.
I mean, it sounds like this is sort of talking about the idea of when a co-op exists, there are a certain amount of products that are, especially in the producer co-op, where when you like share your production, you have individual liability. When does it become the co-op's property, so to speak, and therefore the risk, the quality assurance moves on to the cooperative? That's kind of goes into the concept of some of that could be outlined in the terms of the bylaws and the membership agreement. That could go to the rights and responsibilities as to sort of when that fully transitions. And that sort of idea of indemnification and all of that can occur and should be included in a producer co-op sort of model. So let's sort of use an example of a food product. You have a farm co-op, farmers bring stuff in, and then sadly, some of the lettuce was tainted and some people get food poisoning. So who's responsible? It was bought at the co-op, but the farmers, it was the whatever occurred at the farmers area. If you have in some circumstances, the membership agreement should clarify some of this. Often though, because it was purchased at the co-op, the expectation from that third party is the co-op where it was purchased would have some level of liability. And again, that's where the indemnification stuff can kick in. Because the point of a co-op is somewhat to pool that would be, again, where we go back to the insurance, and you would take on some of that burden. The indemnification you wouldn't want to, I mean, the whole point of some of this is that you're trying to alleviate some of your burden and share some of the risk, share the benefit, share the risk is the concept. So I would say that would be sort of the idea of it. Now, if somebody acted incredibly negligently, that's where you'd want to have some of that level of indemnification. And that said, the co-op should have in its process, if you have certain things like a food product, there should be some level of quality assurance. If you're not doing a quality assurance as a cooperative, is therefore as its own entity, then you're taking on a greater risk than you probably want to, and probably than I think individual members would expect. I don't think members think of themselves as taking the risk of the lowest level, and you don't want to race to the bottom where the members growing, using my lettuce example, the one who uses the most fertilizer and uses the least amount of money to clean it is making the largest profit off of the whole product, but is also exposing everybody to legal risk. So the way you have to do that is to sort of establish that quality assurance concept. Does that make sense to everybody? All right. I have only one more thing in here, and so I'm halfway through. I am going fast, but I only got 5 questions. So we'll keep going here. Entity ownership reporting in PA, consequences for not reporting, any guidance. So Pennsylvania has, depends on the nature of your entity, you have to maintain updates to the Department of State. Different groups have different time periods. I can never keep track of all of them. Nonprofits, I believe, are annual. LLCs, I believe, are annual. Some business corporations are, depending on size, occur less frequently. You do get a postcard reminding you of the process. It's all done online now. The fees are not insignificant. Corporations are due June 30th. Yes. Hopefully, if you're one of them, you've got that postcard. I do find it a very funny postcard, and they send it to you even after you've done the form because it's automatically generated, which can be very nerve-wracking. It's important to do. Failure to do that can have you lose your ability to do business in Pennsylvania. It can, there can be, there's also substantial late fees. It grows fast, and I don't remember the exact percentages, but like you miss 1 year, when you file the next year, you can't file that next year till you fix the prior year. So and that prior year often has like a 10% or some other number. So if you're looking at, 500 becomes 1,000 and 100, 1,050, like it grows fast. So that's something to keep in mind. There's also some other odd elements to this. If you were not up to date on some of your filings, you as a entity, that is, if you got into a breach of contract claim, that's a defense to not allowing you to utilize the court system of Pennsylvania. It's a weird one. It doesn't come up very often, but I've seen that argued that if you're not up, part of not being up on the reporting is that you don't exist as a Pennsylvania entity, and therefore you can't bring a claim as a entity. That's more commonly occurs out of state entities that do business in Pennsylvania. They're found later that they should have registered as a foreign entity, foreign corporation. And if they didn't, then the Pennsylvania courts say, sorry, out of state, you were doing business in Pennsylvania, you didn't do your paperwork, so you're not allowed to utilize our court system. Doesn't seem like a big deal, but it can get very wonky when it does. The bigger issue is definitively you just don't want to be late on the payments. And I can assure you that it gets very complicated to catch up. And nowadays, the Secretary of State, like when you fill in your 2025 one, if they catch that you didn't do it in 2023, they'll remind you. And that's part of the computerization. That wasn't always the case, but now they really do. So they're trying to catch up and clean up their records. It's also, I think it's also just a good idea because when somebody's looking you up, these are all public records. And if there seems to be those gaps, there is sort of if somebody's going through that much effort, they might start questioning whether you're a valid entity. If there's a lot of those problems. So that's like the Pennsylvania one. To the extent you have any federal stuff, it's the same kind of concept. If you're a nonprofit, the 990s do matter. One, there's again, late fees and all those issues. You can easily get extensions for those, but a failure to do those, I believe, has the fee. And I think if you miss, it's either 2 or 3, you are no longer a federal nonprofit, which can be a substantial thing if that's your structure of your business entity. Pennsylvania can go. It's 3. Okay, thank you, Jason. And yeah, it's a big deal. They have that list, and that is certainly something. If you're a nonprofit, grantors and donors will some group go onto the website. Now, given the IRS's tendency not to always keep things tight, you generally aren't going to get the 2024 stuff in until September-ish, has been my experience. So, you know, you're looking at 2023 right now, but it's still out there. So those are the questions I have now. So now I'm going to open the floor. I'd love to hear some more, any kind of legal questions. The more tricky they are, the more I'm going to start typing off to the side of the screen, but I'm happy to sort of discuss anything anybody has. Otherwise, I will just start winging it. And you don't want me to do that. So, yeah, Jason. You're muted still, Jason.
Got it. I lowered my hand, but didn't unmute. Well, I was just saying, thanks. This has been helpful so far. Little bit of context. I'm a tax accountant here in Pittsburgh. Okay. One of the questions that comes up, not super often from my clients, but often enough that it's become a little bit of a flag for me, and is a place that is a little bit of a gap in my knowledge that I'm wondering if you could fill in, is in questions of change of entity. So a lot of times I'll have folks come in, they have solely owned the business for a while, or owned it with a partner or something like that, and they say, we want this to be an employee-owned business now. I don't know if you can kind of generally like sort of give some introductory guidance to the legal issues around that sort of change of entity.
Sure. Yeah, hold on. I'm going to pull up. I actually wrote something about this to Ron a little bit ago. So I'm just trying to figure out if I can find it, because I, rather than trying to remember what I wrote, it would be helpful for me to actually use it. I will say just initially, it's not as simple as transitioning. You're sometimes you're kind of in the process, you kind of dissolve and reform, or you do a merger with a new entity. You can do a successor entity, but that's sort of, again, you form a new entity and you transfer all your assets over. Shoot, I can't find my note on that.
Yeah, so from a tax perspective, I know the kind of the main thing that shows up on my radar is that a transaction like that should be able to be a non-taxable event. And the question is to make sure that it actually qualifies as a non-taxable event from a compliance standpoint.
I see that when you get into tax, that's probably more in your area. But yes, you're right. If you do it correctly, the successor entity will absorb all of the assets and liabilities of the former entity. You will do that as part of a transfer. There will be some tax implication, obviously, when you move from certain structures. So if you were an LLC, the LLC is owned by those individuals. They might have and then you're moving to a different, and if you move to, let's say, an S Corp or a C Corp, like those are going to have different tax structures, because LLCs, the money passes through. The other one, the business itself owns property and owns it. And then the big thing would be in that transition, if all the assets transfer, you have to be careful to not have it look like a fraudulent transaction, so that it looks like the LLC, like the members of the LLC are trying to duck their liability responsibilities. So, that I would say is the one big risk in there if it looks fraudulent. But for the most part, it's very much, it's possible to do. The one I had was a specific transition from an LLC to, I believe it was a corporation, and I can't find my. Sorry.
That's the question that I get the most often as well. Usually an S Corp LLC looking to change to a corporation.
Yeah, that does seem to be, yeah. So I'll keep looking for that. There was also another one that I've seen a couple people bring up, which is the, and I'm just bringing this up just to talk about this while I continue searching. I know it seems like a lot of Pennsylvania is unique because it allows for shares in cooperatives, and that's a very attractive structure. I've noticed the biggest uncomfortableness is the SEC requirements. And so more and more people want to use the single state, what's called the Section 3A11, which allows for a single state offering exemption. That is certainly allowed. However, it's important to, the exemption exists. If you are in the intrastate offering exemption, you are allowed to avoid SEC filing requirements. You still have to abide by state filing requirements. However, I think a lot of people don't quite get the safe harbor provisions. It's you have to be organized in the state. The officers, partners, managers have to also be in state. That means members primarily have to be in state, or all have to be in state if they're the ones who are getting the shares. You have to do business in the state. I know that seems weird, but sometimes, everybody's doing business out of the state and they try to use, let's say, Pennsylvania as a harbor. And then the offers are limited to in-state transactions. Sales can be out of state. However, you have to sort of keep most of it in state, limited to persons with you reasonably believe are in state. And then a written representation from each purchaser as to residency is required. So the point of this is possible. It is an attractive feature. I think a lot of people do like it. I just want to make clear it's not as I don't think it's as easy as some people think it is to manage, because it's very easy to run afoul of it, and it does require that you stay alert to all of that, all of those nuances.
Can I ask a follow-up on that one?
Sure.
Also, Will?
Sure, absolutely.
So if you I've seen cases of co-ops that are kind of very vigilant about screening folks as they're coming in.
Mm-hmm.
What about the situation where over time, some members just scatter to other places, move elsewhere, whatever, but remain members? They were screened at the beginning, but the density of members in Pennsylvania might decrease over time. Is that a compliance issue as far as the safe harbor is concerned?
So the way it is the offer and sale is what determines it. I think that shouldn't be a problem, but all offers and sales of the stock have to be in state for the exemption to apply. If somebody moves after the fact, they don't have to divest. However, if they do intend to divest, they have to divest to somebody in the original area. Where I don't know how that would work is if there's a successor entity that's more or less taking on, but that successor entity is no longer in there. If it's an individual, if it's an inheritance, I would be very cautious in structure like that to make it clear to the individual that it's non-transferable once they're out of state, and the only thing they can do is sell back to the cooperative itself. That way, you're keeping it in state. It would be I'm not aware of currently the SEC putting a lot of effort into go to smaller entities on this issue. However, the price of getting it wrong would be the SEC coming and knocking on your door and demanding potentially years upon years of stock sales and going back and filling in all that paperwork, which I've only helped one entity do an SEC thing, and it was that's way beyond me. I don't do security exchange, but it's a lot. That's all I can say. It was just way more paperwork than I'm comfortable with, and I do paperwork. So the question I had is there is an LLC, which is a two-person entity with asset and no income. No, this is a different question, but this was sort of a structure. Somebody wanted to convert from a corporation to an LLC, it looks like. So slightly different thing. But that one was to create the LLC, and then you move everything, and the same way it could work the opposite direction. Again, there is a method of doing some corporate changes. I have not found Pennsylvania particularly conducive to that. And certainly when you move, it's doable when you move within like sort of the corporation world, but it's not really going from an LLC to a corporation is not that easy, because they really are very distinct entities. The LLC is owned and has members. The corporation is and the LLC is the members. It's a limited liability corporation, but the members are the LLC. And if you're a single member LLC, it's a pure pass-through entity. that is not the same thing as a corporation. The corporation exists on its own. It pays taxes on its own. And because of that structure, you can't, that's where you really have a tough time going between the two. And the best way to do it is to form the one that then takes on the assets and all of the control of the other one. The other structure I have seen in some circumstances is where let's call it a parent organization takes over all of the sort of takes over, and the other one becomes like a subsidiary. That is a common structure you'll see in the corporate world, where a lot of LLCs are. So a lot of LLCs are owned by a single member, which is a corporation. That's a huge structure system, but that's the one where you kind of create little pockets of liability. You see that. I believe a lot of hotel chains do that, where each hotel is actually technically a separate corporation. So you could emulate that if you were wanting to in a larger co-op. I'm impressed if your co-op got that big. Good for you. I think for the most part, when you want to move from LLC to corporation, the secret is to you want to make sure you avoid any appearance of impropriety or inappropriate dealings. So if you're going from LLC to corporation, that means all the members have to be getting the same benefit. If there's any kind of sale purpose, you want to make sure you're reporting that as the proper level of income. If you're going from and then you're forming cooperative at the tail end of that, you want to sort of make sure how you're doing that. If you're going the other direction from corporation to LLC, the members have to be included and made clear a part of it. And why are the members no longer having that ownership, because now the ownership is coming in LLC. That's really the tricky part. Where it can sort of be problematic is if it at any point appears to be an unfavorable tax haven, or if you're trying to trick the IRS. That's where things can come down on you. The sort of level of auditing can come down, and really it shouldn't be a problem because of the one, I don't think that's what people are doing as asset, but it's where paperwork failures can make it look like there's an appearance of impropriety. That's not a term really in the accounting field, but it's a good use of term to sort of get that sense. If somebody thinks there's something wrong, that can then make the IRS come and knock on your door, and then suddenly you're having it audited and answering a lot of questions. And again, it's a pain in your butt to deal with, but it's not, you might come out clean on the other side, but it's a lot of man hours to get rid of that. Let's clean that up. Thank you, Jason, for that. I'm gonna, if anybody doesn't want to pop up as questions, you can type them in. I do have the chat feed up.
Yeah, it's good to see more people have jumped on in the course of this conversation. So welcome to Patrick and Vidya. Yeah, if folks, this is oh wait, I forgot to ask legal Q&A, so come with the cues. Yeah. So feel free to raise your hand, come off mute, or drop in the chat.
I'm trying to see some other questions I've had recently that have repeated. I can't think of the transition stuff was one. It's another fun one. Taxes. I mean, I get tax questions, but I'm really not. I think the big secret to know is lawyers are not really who you should be talking to on most tax questions. I did take a tax class in law school. That was 20 something years ago, and I haven't thought a lot about it besides when I do my own taxes. And I don't really like doing that. So,
well, Jason here, we can have like a two-headed consultant bit going on.
Living and breathing the tax code is so much fun. The ever-changing tax code. I guess that is one thing I would add to. This goes more to the auditing. The auditing requirements, certainly for nonprofits, but even for corporations, that's an ever evolving area. And something that I've noticed is there was a change in law. I don't know if it was a change in law or a change in CFR, which is the federal regulations, but the end result is auditors now have more exposure and more liability, and therefore I feel that process has become more intensive. And the reason I'm bringing this up is I think if you are sort of dealing with this in the new world, it's good to be aware that when you deal with your auditors, one, they're probably going to be asking for a bit more support for things, and two, they're going to be looking a lot closer, sometimes to the benefit, sometimes it's trickier, and it's something to be thinking about. I think it occurred. It seems to have occurred over the last few years, and I don't really know exactly what sparked it, but there is, I know, personal liability for the audit entities. I guess it occurred something with Mazars resulted in this occurring, and now it's a lot more intensive. The nonprofits I'm involved with, I've noticed it, and then I think for some of the corporations, smaller business ones, I've noticed that as well. Anything where you're touching on auditing, which is a lot of practices, any mergers and acquisitions, and that kind of ties into what we were just talking about. These things are being a little bit more watched, and I think the nature of previously, where it was a letter that sort of said, the auditors frequently say something to the effect of, based on what I was given, I'm pretty confident. Now there's an expectation they dig a little bit deeper, and that digging a little deeper means it takes a little longer, so you don't want to wait to the last minute, and it means you're going to have more effort on your end, which is probably good for all of us to be a little bit better with our paperwork, but it does make things hard. My name's Will Pillsbury. So I'm an attorney. Somebody just asked me to introduce myself. I have worked with KDC now for, I guess, since about 5 to 6 years, maybe even a little bit longer. I worked with them initially in actually a transition from one 501 status to another, and then since I worked with them on that, I've been helping them with sort of some of the other legal consulting kind of stuff.
Yeah, including, right? So Jason and Melissa and myself were all part of the Northwest PA Investment Cooperative, and you looked over our articles of incorporation changes. Melissa was spearheading that process, so she's glad to have a face to the name. And I think you might see some of our you might see some materials come up as we change our bylaws as well too. Great. It's fun to make these connections in real time.
So any other questions at this time?
We already named this session. Oh, wait, I forgot to ask.
Yeah.
So if you forget to ask today, there's not
Yes.
going to be another one. This is your chance to ask the question
You
forgot
can.
to ask.
I don't mind, as long as it doesn't take too much effort. I'll have to answer questions. I don't want to volunteer complete promises, because I made that before and suddenly I get the most complex question that's clearly related to a very specific thing. Like, how do I respond to this lawsuit? And then, that I can't do for you. So, no other questions this time? Okay. Oh, nice. Are they attorneys in Pennsylvania? Melissa?
We may never know.
Nice.
Right. Well, I'll just underscore, Will has been a great partner to KDC. And so we are able to tap him both I think right for Pennsylvania clients and clients based in New Jersey as well. So is that correct? Am I misspeaking?
It is. I would just add that Pennsylvania has very well developed and pretty thought out statutory and history with cooperatives. New Jersey doesn't. New Jersey doesn't really have anything specific. You are just sort of existing as an entity. You can call yourself a cooperative, but it doesn't really have the same history or legal structure as Pennsylvania with cooperatives. Therefore, you're kind of creating it as you go a bit in Jersey. It's a very different entity. So yes, I can, but I want to make clear when that happens. Often what I find is people really like the Pennsylvania's flexibility and thought, and then you sort of insert it into New Jersey via use of bylaws, and so you kind of create it, but you're not really relying on sort of the same structure. You're just sort of existing as a New Jersey corporation, and you're making yourself a cooperative, but you're not. You don't have that same kind of guidance, which is too bad. But it's just part of the nature of the history. I think Pennsylvania has a pretty unique history in this field. Can't tell you who else does, but it seems like Pennsylvania, and I've seen a lot from California, so I think it's similar with some really advanced thoughts on cooperatives and real use of it, which is nice. I can tell you a pretty funny thing. Ron wrote to me recently asking me about something called the Capper-Volstead Act. And I really appreciate somebody who decides to dig deep into 1920s legislation to ask me questions. You'll be shocked to know it was not something that I had ever come before. So I got to read up a bit about it. It was interesting. That's a farmer, individual farmer, and sort of nature of some of the rules of farming. But yeah, what you discover is there's a lot out there. Not as much as you would think, but there's a bit out there. And then the Sherman Antitrust Act came up in part of that discussion. So I was really reading some older thoughts, and that gets hard because the writing has changed a bit from the 1920s, 30s to today. 100-year-old decisions can be a little confusing.
I have this is a bit couched in a sad story, but USDA's rural development, their cooperative development department has had to clear out their library as they close down a little bit, but we've got a lot of materials as they were clearing out their library, including this piece about understanding the Capper-Volstead Act, which is I've got some literature happy to share.
I wish I had that.
I'll scan and send you a copy.
Thank you.
Great. Yeah, so again, thanks Will for being willing, I think, to take questions tonight and being so willing to be a helpful player in the cooperative ecosystem, certainly for co-ops in Pennsylvania and New Jersey as well, as we continue to build that ecosystem. Hannah has dropped in the chat a survey for today's session, so hopefully folks will, if you're here today, please take some time to complete that. We've got one final session coming up in 2 more weeks, and so yeah, we hope to welcome folks back for a session on marketing your cooperative advantage. But yeah, that's a great question. So there's like a lot of conversation in the co-op world, but yeah, asked if the USDA library archive, if they'll archive some of their info before they close out. And there's lots of talk about where this stuff can live, where it can live digitally, because it has to be taken off of USDA's website. So it's I think Noemi from KDC, actually the data comment, she's part of the data commons, and I think they've been talking about maybe hosting some of it, but there's lots of dialogue right now. So one at a time. Wonderful. Great. Well, thanks folks for being here. Will, thank you so much for your time and knowledge and answering some of these
Sure.
dry but important critical questions for the co-ops here and who will be watching later in the recording. So thanks so much.
Thank you everyone for coming tonight and have a great evening.